Hello, my name is Adrian Lifely. This is the second short video about litigation funding. In this video I want to discuss how a defendant should deal with the possibility that the claimant may have obtained litigation funding for the claim against it. The first thing to note is that the defendant will not necessarily know whether the claimant has obtained litigation funding. This is because there is no legal requirement under English law for a claimant to notify a defendant that it is using litigation funding. However, in civil or commercial proceedings, it is sometimes possible for a defendant to obtain a court order requiring the claimant to specify whether or not it has litigation funding, and if it has, the identity of the funder and the terms on which the litigation funding is being provided. To obtain such an order, the defendant first needs to have some evidence that will satisfy the court that the claimant is in receipt of litigation funding or might be in receipt. This can be an inference if there is evidence that the claimant does not have the financial resources to fund the claim for itself. Therefore, if a defendant suspects that the claimant may have litigation funding and wants to confirm whether or not this is the case, it could write to the claimant's solicitors to ask for this clarification and to threaten to apply to court if the claimant refuses to answer the question. Sometimes, for tactical reasons, a claimant will voluntarily notify the defendant that it is being funded by a third party. Why might it do that? The main reason is to put pressure on the defendant to settle out of court. This arises because the availability of funding means the claimant will definitely be able to fund the litigation and will not be constrained by how expensive litigation is. There is also the point that the mere fact that the claimant has succeeded in obtaining litigation funding is a signal that the claim against the defendant is likely to succeed. This is because no litigation funder would agree to fund a case unless it has vetted the claim as being likely to succeed. This is another reason, therefore, why the news that a claimant has secured funding may increase the pressure on a defendant to try and reach a settlement of a claim. In terms of the way in which a case is run and the stages the case goes through, the existence of litigation funding won't make a difference. The funding arrangement is invisible to the defendant, and unless the defendant applies to the court for a disclosure order, it's invisible to the court as well. Certainly, the outcome of the case and the judge's decisions won't be affected one way or the other because the claimant has litigation funding. Where a defendant wins the case and the court orders the claimant to pay the defendant's costs, can the defendant recover its costs from the litigation funder? This can be a very important issue for the defendant, for example, where the claimant is impecunious and can't afford to pay the costs. The general position here is that the court is likely to order a funder to pay the defendant's costs, but this will be subject to a financial limit. That limit is known as the Arkin cap, after a case of that name, and this is the principle whereby a funder is only liable for the successful defendant's costs up to the amount of the funding it provided to the claimant. In saying this, it is important to note that the funder's liability for the costs of the defendant is, like all matters concerning costs, a matter for the judge's discretion, depending on the circumstances of an individual case. There are no hard and fast rules about what proportion of costs can be recovered from the funder, therefore. Furthermore, it's possible that the Arkin cap might in future be disregarded, allowing defendants who have incurred more costs than the claimant to recover all of their costs. Indeed, this was the recommendation of the recent Jackson report on costs in civil proceedings. So watch this space for possible changes in this area of the law. As always, this video is not legal advice, and please obtain specific legal advice about your situation before you take any decisions.